bring you details of our stories. We start with the Supreme Court because it has rejected an application by the Speaker of Parliament, Albert Bagbin, to overturn an earlier ruling that barred him from declaring 4 parliamentary seats vacant. This decision adds a new layer to the legal debate on the Speaker's authority versus the judiciary's influence over parliamentary procedures. Now, the case has been adjourned until November 11, 2024 for further hearings. ChannelOne News' Jude Duncan was at the Supreme Court and he came through with this report.
The Supreme Court of Ghana has ruled against Speaker of Parliament Albert Bagbin's attempts to reverse a decision blocking him from declaring 4 seats vacant. Speaker Bagbin's application also sought to nullify a writ from the Majority Leader Alexander Penyo-Markin, which requested that the judiciary intervene to prevent further declarations on the contested seats.
Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Earlier, the Supreme Court had dismissed an objection from the Speaker's Counsel challenging Justice Ernest Jewu's presence on the bench, labeling the objection as misconceived.
To the preliminary objections raised to paragraphs 21 and 49 of applicant's affidavit will be addressed in the final ruling on this application. On the objection to a panel member being a former member of a political party, this court must take judicial notice of the fact that within the ranks of the Superior Court is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention. It should be well understood that when Parliament approves a qualified citizen to be a justice of the Superior Courts, pursuant to Article 1284, the representatives of this country have appreciated the ability of that qualified person to contribute to justice delivery in the country. Second, the subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived.
Following extended arguments, the Supreme Court adjourned the case to 11th November 2024, when it will continue hearing and potentially issue a judgment on the substantive matter. This adjournment follows the Attorney General's assertion that Speaker Bagbin's continued legal representation by Thaddeus Sori lacked prior approval from the Public Procurement Authority, deeming it unlawful. Attorney General Godfrey Dame clarified that he refrained from initially contesting the Speaker's Council's eligibility as a mark of respect for Parliament's leadership.
As I said, I've always tolerated the Speaker of Parliament and his representation, even though I know it's not lawful. And of course, it is not. You see, and the point must be made. It is not an attempt to prevent the Speaker from having representation. If the Speaker wants to have a lawyer, the Speaker must procure the lawyer lawfully. And then, as I said, the Attorney General, even when he's seeking the service of a lawyer to represent the government in cases outside the country, in foreign court, goes through PPR approval. all the time. Even the Chief Justice, the former Chief Justice, who was, with all respect, using the services of State Sorry, had to go to PPA approval. And I know for a fact that he has not received any PPA approval. And so he's in flagrant violation of the provincial law.
The Supreme Court has adjourned the case brought to it by the leader of the NPP caucus in Parliament, Alexander Penyumakin, against the Speaker of Parliament on the 4 vacated seats to 11th November 2024. This was after some long hours of debates from all parties involved in the case. Reporting for Channel One News, Jude Duncan.